Just Say No, or spousal refusal, is a Florida Medicaid technique that can be available when one spouse is living in a facility, either an ALF or nursing home, and the other spouse resides in the community at home. This video will discuss how the spousal refusal Medicaid planning technique works. Spousal refusal, or Just Say No, is a Medicaid planning option that takes several steps. Step number 1, transfer all of the married couple's countable assets into the name of the community spouse only. After the transfer of assets, but prior to filing a Florida Medicaid application, the community spouse signs what's known as a Notice of Spousal Refusal, which indicates his or her refusal to be obligated to pay for the Medicaid applicant's care. The Medicaid applicant then must sign an assignment of support rights to the government, which in theory allows Florida to take the position that it could sue the community spouse for reimbursement for any amount it pays for the applicant's care and support. While no one likes the threat of a lawsuit, it should be comforting to know that Florida, to our knowledge, has never sued a community spouse who refused to make his or her assets available to the spouse receiving Medicaid. Furthermore, it is our belief, based on legal precedent, that Florida would not file such a lawsuit. This is based on the fact that in 1995, Florida abolished the common law doctrine of necessaries, which gave one spouse an obligation to financially support the other. So as the law currently stands, there's no requirement for spouses to support one another. While there's no guarantees, and of course the government could try to advance other theories, we believe the government is unlikely to file suit. Politically speaking, it just wouldn't look good for the government to sue an elderly person for support rights. Your elder care attorney will prepare all the needed spousal refusal documents, including the Notice of Spousal Refusal and Assignment of Support Rights, and guide you through this process. Let's discuss some of the drawbacks associated with spousal refusal. Other than the threat of a lawsuit, the primary drawback involves the income that the well spouse would normally be able to receive from the sick spouse receiving Medicaid. Essentially, Medicaid says you can't have your cake and eat it too if the community spouse is utilizing Just Say No or spousal refusal. Generally, to avoid impoverishing the community spouse who is not applying for Medicaid, the community spouse may be entitled to a portion or all of the Medicaid spouse's income. This income allowance diversion is referred to as the Minimum Monthly Maintenance Needs Allowance, or MMMNA. But if you're utilizing spousal refusal, DCF takes the position that if the healthy community spouse is unwilling to support the one receiving Medicaid by utilizing a spousal refusal strategy, then the community spouse will not be entitled to the MMMNA income supplement from the Medicaid spouse that they would otherwise be entitled to receive. Essentially, if spouse X refuses to share assets with spouse Y, spouse X then can't take advantage of the income diversion as well. Your elder law attorney will be able to lay out the pros and cons of spousal refusal compared to other Medicaid planning techniques. Call and schedule an elder law consultation today. We assist our Medicaid clients throughout the state of Florida. You can schedule a consultation by calling 305-931-0478 or visit elderneedslaw.com.